This is an AZ Court Help Legal Talk on spousal support.
Again, I'm, as Sarah said, Steve Wolfson. I'm a partner with Dickinson Wright here in Phoenix. I've also had the honor of being the chair of the State Bar of Arizona Family Law Section, and I assist with legislative issues such as the one we're going to talk about today concerning spousal maintenance. Our topic for today, which is the spousal maintenance guidelines and the spousal maintenance calculator. So to begin with, the spousal maintenance guidelines came out of legislation that was passed in 2022. It's important to know, and I'm not going to go through the entire timeline, but it's very important to know that September 24 of 2022 is the effective date of this legislation and the new spousal maintenance guidelines. So what does that mean? That means that all cases that were filed on September 24, 2022, or after these spousal maintenance guidelines will mandatorily be used by the court, any court. And that means in practical terms that most judges, most counties are requiring parties to submit a calculation based on the calculator, and I promise we'll get to that, as part of any paperwork provided to the court if spousal maintenance is an issue. So similar to child support, whenever child support is an issue, the judge will ask you for a copy of a child support worksheet. It may not be the child support worksheet that the court uses, but they want to know what is your calculation. So whether you're an attorney or an individual representing him or herself, the court will ask in all cases for a proposed form of child support worksheet. And that's done by using the child support calculation, which is on the most counties' websites. If not, it's available always through the Arizona Supreme Court website. So this is similar to that process, but there's a specific date that applies. And that's based on when the legislation was passed that changed the statute, the spousal maintenance statute that's been in effect since I started practicing, and that's ARS 25-319. And I'll talk about that real briefly in a second. So again, when I say effective date, that means, again, if your case was filed on September 25 of 2022, September 26, October of 2022, going forward, these guidelines apply, and it's mandatory that the court applies the guidelines, the new guidelines. If your case is an older case, and for some reason it's ongoing, and let's say it was filed in July of 2022, the court does not have to apply the guidelines. And the more traditional approach with regards to spousal maintenance, looking at amount and duration, the amount, obviously amount of money, duration being the period of time, either months or years, and the court determining what's appropriate, what's just under the circumstances, then the more traditional approach of the court subjectively determining that amount, that would be in effect. So I hope that's clear, but it's a very significant change in terms of the cases where these guidelines now are applicable. Anything after September 24, 2022, that's when you're going to want to become more familiar with the spousal maintenance guidelines and the calculator. I'm by no means suggesting that that's an easy task. There's been a real learning curve for everyone involved, judges, attorneys, and individuals working on this issue on their own. It's not easy. It was designed as a member of the committee, or one of the members of the committee, I can tell you that we did our best to make it as user-friendly as possible, but it's not easy. And so just like it takes some familiarity with the child support guidelines, it's important to familiarize yourself with the spousal maintenance guidelines, and hopefully some of what I say will help you become more familiar with the spousal maintenance guidelines. The court may award spousal maintenance pursuant to the guidelines only, number one, for a period of time, and two, in an amount necessary to enable the receiving spouse to become self-sufficient. Self-sufficient essentially is, how do they become financially independent? And the amount, so again, we've got two parts to spousal maintenance. We've got amount, and we have that period of time that I referred to as duration. So the amount comes directly from these guidelines, and the use of the spousal maintenance calculator that we'll get to in a second. And then the court is, and I'll again read from the statute, the amount of spousal maintenance resulting from the application of the guidelines, that's what we're going to get to, will be the amount of spousal maintenance ordered by the court, unless the court finds in writing that applying the guidelines would be inappropriate or unjust. And that's the small foot in the door to have what's called a deviation, an amount ordered by the court that is different from how we apply these guidelines and what comes out when you prepare the spousal maintenance calculator and give that sheet to the court. The duration, as you'll see, and we'll talk about briefly, is not something that the court itself can change. That is set in stone based on the guidelines. And so the court does not have the discretion that it used to have. Generally, there are very few exceptions, but generally the court has to use the amount of time that is in the spousal maintenance guidelines. So we're not going to go through every page right here, but this is the first page of the guidelines that you will see if you go to the Arizona Supreme Court website. This is the background explanation that if you're confused about any part of it, especially any part that we don't get to in the next 45 minutes, this is where you would go to try to figure it out. And I'm not trying to be facetious, but there are examples within the guidelines. There are explanations for each of the sections that have to be done to do the calculator itself. So again, if you're familiar with the child support guidelines, it's the same sort of process. You're just going to go to the spousal maintenance guidelines, read through it, see if your question can be answered that way, and then go back to the calculator to try to complete it in the best way that you can. Real briefly, the guidelines were put together to allow spouses or attorneys with this issue to calculate an amount and to give some level of consistency between awards, spousal maintenance awards ordered by the court. Historically, these awards, different judges, different cases, a very broad swings in spousal maintenance amounts. So the Arizona Supreme Court and the legislature wanted to have more consistent awards. This is one way to do that. And then it provides, as I've said before, guidance or instructions, literally, to either attorneys or to spouses representing themselves about how to calculate spousal maintenance. So again, now there's direction and instructions that didn't necessarily exist before. And third of all, if spouses, attorneys, understand how and receive these directions about how to calculate spousal maintenance in the same way that the court would look at it. It's the idea is that we may have more spousal maintenance issues resolved by agreement, so everybody can get on the same page theoretically, and it would narrow maybe the debate over a particular spousal maintenance request. Obviously, with different circumstances in different cases, there may still be a difference of opinion, but at least there's now more guidance with the spousal maintenance guidelines in effect to give that background to both the court, attorneys, and individuals working on their own about how this issue should be approached. This is the spousal maintenance calculator. This is not a fillable form. This is just a screenshot that you would see if you go to the Arizona Supreme Court website. There is another version that we'll bring up in a second, which is an Excel spreadsheet that can also be used and printed for the court. They should come out to the same amounts. So beginning at the top here, you see background information, fairly straightforward, your case number, the names of who's involved, the date of marriage, the date that there was service of process. So every time you see bubbles there, that allows you, and it should be a hyperlink directly back to the spousal maintenance guidelines that we had open a few moments ago. So the child support guidelines now do this as well. It allows you, if there's a question and you're in the process of filling this out, you click on the hyperlink and it takes you, or should take you, directly to the section of the spousal maintenance guidelines that deal with the issue. But it all begins with the family size. So you calculate your family size. You see that there. And this is between 2 and 5. So the minimum size is 2. The maximum size is 5. 5 is, even if the household is bigger, 5 is the largest count of family members that the data, without getting too far into the weeds, is largely based on USDA, U.S. Department of Agriculture data of expenses of households throughout the country. There have been some modifications, tweaks to the data used by the guidelines, but it's between 2 and 5, and that's what the data looks at. You do not include other persons that you don't have an obligation to support. So let me give you one example. There's a cousin living in the house, and as a cousin, there's no formal legal obligation to provide support, meals, housing, clothing, etc., to that cousin. So even though that cousin is in the house, living there, that cousin would not be part of the family size number. Same thing with a child. If there's a child of another relationship that the spouse, husband or wife, is not paying child support for, you would not include that other child, even though that child is living in the house. So next you see mortgage principal. The easiest way I can explain it is that there are certain expenses that, again, are part of the underlying data. So the data already counts for expenses such as rent, interest, taxes, insurance, and other similar housing expenses, but it does not include, for some reason, principal payments. The best reason I can explain is because those are treated as a buildup or acquisition of an asset, which is the equity. So when you pay mortgage principal, you're building up equity in a home. And so the expenses that were used to come up with these guideline amounts don't include the principal. It's obviously an expense, and that's why there's a separate place to put the mortgage principal. It is mortgage principal only, not mortgage, not the entirety of the mortgage, if in fact the mortgage is principal, insurance, PITI, principal, insurance, taxes, principal, interest, taxes, and insurance. I apologize. It is only the principal amount. If you don't know it, and I'm not trying to be facetious, obviously that's an issue or a document or information that can be acquired through discovery. If you're on the mortgage, you can call your lender. If you don't happen to have a copy of the mortgage statement, if you have the mortgage statement, it's usually broken out by principal and interest. You only want to include the principal amount there. So this is very similar to the child support process. Again, if you're familiar with the child support guidelines or you've done a child support worksheet, you started with an amount of income for yourself and either your spouse or ex-spouse. This is very similar in terms of the way that the spousal maintenance guidelines approaches it. The types of income are virtually identical. Salary, wages, commissions, bonuses, dividends, severance pay, most types of military pay, not all, pensions, trust income, Social Security income, and then if there are payouts from retirement, such as a current pension amount that's being distributed if the spouse is of that age, over 59 and a half or older, you would include all those amounts in the spousal maintenance income. So there's really not a big difference. There, again, the court can look at overtime. The court generally would not include overtime so as to force a spouse to work overtime to support the spousal maintenance amount. But if it's historically a part of what the spouse works or earns on a regular basis, for example, I'm aware that most or some utilities, APS and SRP, will regularly pay an individual some overtime because of the way that the work schedules come out. And so if it's not something that would be unfair to include, the court has the ability to look at that. Very similar, again, to the way that the court generally would not include overtime in a child support calculation, but has the ability to do so if it's historically earned. The court also, and this is different from the child support guidelines, can include and is supposed to look at whether there's income from property. So there's an exclusion. You don't look at property. You don't look at the first $100,000 of property. And I realize this may not apply in many cases, but let's say there's an investment account and there's $200,000 in the investment account. You would not look at the first 100,000. You would look at the other 100,000, and you could say, my spouse has access to that money, and the court automatically would include a 4% rate of return on that 100,000 and include that as additional income, whether it's being taken or not. So you'd multiply the 100,000, you take 200, subtract 100, and multiply that remaining amount by 0.04 or 4%. to come up with this additional amount of income that could be received from the property. This is one of the differences between the child support guidelines and the spousal maintenance guidelines. And that could be stocks or bonds or deferred compensation. It's just something to think about if there are other assets that could be included in the calculation. As is done with the child support guidelines, you can also attribute income to a spouse. What does that mean? It means that if a spouse is choosing not to work full-time, the court can attribute full-time employment to a spouse. The court has a variety of factors it would look at as to whether or not the spouse is underemployed, or the reasons why the spouse is unemployed, and whether or not to add what is essentially a fictitious amount of income to the calculation, or whether minimum wage should be used. So again, if the spouse, if both spouses are not earning regular wages from a third party and not paid on a regular basis, you should look at the spousal maintenance guidelines for how to attribute income and put it in the calculation. The factors, like they are in the child support guidelines, are very similar. Looks at the person's earning ability, their history of employment, the education that they have, their prior work experience, what are their physical condition or limitations, if any. And those are all the types of factors that the court would look at to determine whether or not there should be amounts attributed, even though the spouse is not actually earning them. The court could decline to do that, as with the child support guidelines, if the spouse is taking care of a young child, or the spouse is retired, or if there are physical or mental health issues that otherwise might prevent that spouse from working full time. So again, you see that right below the income, actual spousal maintenance income. And again, this should be put in on a monthly basis, not annual. And then the line below that is additional or attributed spousal maintenance income. So again, if there's not a paycheck coming in on a weekly or monthly basis, that's where you would put attributed spousal maintenance income. Then you come up with a total, and the attributed is where you would include income from property, which I talked about a few moments ago. That's where the court uses a 4% amount of return on that property. And again, that was part of the court's determination that a 4% would be generally reasonable. So you see low, midpoint, and high. And so after you've input these amounts, you're going to see this range. And there could be a reason. This is where, again, there's some discretion of the court to look at low, in the middle, and then the high amount based on all of the circumstances. Maybe the spouse has been out of the labor market, hasn't worked in over 10 years, and it would take them, he or she, a while to get up to speed. And the court might use the high end of the range. Conversely, the court might look at the low end of the range if the person had been employed recently or is actually employed now, and there isn't that much of a difference between the two spouses' incomes. So this is all based on the expenditure data that I described a little while ago. Not trying to avoid the issue, but it's very complicated. The data that's behind all of this, behind the calculator, but it's supposed to reflect the monthly living expenses that a spouse requesting spousal maintenance would need on a monthly basis that is similar to the expenses that a spouse might have had during the marriage. So then what happens is the spouse, if the spouse is employed, the spouse requesting spousal maintenance, that amount will be subtracted, and that gets that ends up being part of the calculation and an adjustment. And so on this worksheet, this calculator, on the left-hand side, right below calculations, you see the amount that's called deviation. And before we get to that point, let me say a couple things. A few examples I'll just describe. So if you have a spouse who's making $200,000 a year and a spouse who's making $50,000 a year, doesn't matter which one, you're going to get a range, but then the range is going to reflect the spouse who is already earning income. So it essentially subtracts their earnings and then comes up with an adjusted set of ranges for low, midpoint, and high. This is all gross income. It is not net income. It's gross for both the recipient, the person requesting, and the person who's being asked to pay. And so be sure to include the gross amounts, not the amounts after taxes. What this particular worksheet does not show is the duration or the amount of time. And let me say a couple things about the marriage length that's used. Does not include periods of time from before the marriage. So there might have been, a time when the couple lived together, may even have had children together, but then didn't get married until later on. It's only the time period from the marriage forward. So the additional period of time is not included, and it goes through the time when the petition, the beginning of the case, is actually filed and served on the other party. When that happens, the time period is cut off, and that's the length of marriage that we're looking at. The standard range, again, you have to look at the guidelines, but this is where the awards are probably for a shorter period of time. So, if you ask me, Steve, well, overall, how does this really change things? What we're seeing are higher amounts, but probably for shorter periods of time because of the guidelines and the ranges that have been set up by the court. So, for example, if the marriage was less than 2 years, less than 24 months, what you're going to see in the guidelines is that the spousal maintenance is only supposed to be between 3 months and 12 months. So when you look at the guidelines, you're going to see, you compare the length of marriage and then you look at the duration. If you've been married for 2 years or less, you cannot ask for 2 years of spousal maintenance. The most you could ask for and the most the court could award would be 12 months. So you go to the next range. If the marriage is between 2 years and 5 years, the most the court could provide would be for 36 months or 3 years. So again, the court has a little bit of flexibility there, but they're generally shorter periods of time than what might otherwise be experienced under the more traditional calculation of spousal maintenance. So, for example, 120 months of marriage to 192 months, the court cannot provide spousal maintenance beyond 5 years or 60 months. So there are very specific time periods in the guidelines that you would use for calculating and presenting your position on spousal maintenance. There are some exceptions to that. If you or the other party has a specific and verifiable disability, the court can look at whether it is indefinite, meaning it's unclear how long that disability will be in place. Broken leg, fibromyalgia that's acting up, that's not been treated, or whether it's a permanent disability. So when I said earlier on that the court is pretty much stuck with these ranges, there are a couple exceptions, and whether or not there's a disability affecting the party who's requesting spousal maintenance, either an indefinite disability or a permanent disability, the court can look at those situations and decide whether it's applicable. It's the burden on the person who has an indefinite disability to present that information to the court, to explain why the court should look at the spousal maintenance award differently because of the disability, either a mental health disability, a physical disability, or possibly even a combination of both of them. Few other points. If the court is going to deviate, and you'll see that there's a box there below the calculations is a deviation requested. So that is the term of art. That's the legal reference to the court doing something, either an amount or a duration that is unlike outside of the amount range. So the court only has specific ability to use a different amount of time when there's an indefinite or permanent disability. But if the court's going to look outside of these ranges, the calculation, the amount ranges, the court has to provide specific reasons in its decision for why it should deviate. The parties can also agree to do a different amount. That's not a deviation. That's an agreement that has to be explained to the court. But the court has to look at the deviation if requested, and first of all, determine why the amount within the range is not appropriate in that particular case, what the amount would be without a deviation, and then what amount is being ordered using a deviation. So it's kind of the get out of jail card for free from Monopoly. If the case is very unique and there are circumstances that you believe don't allow for an appropriate and just award of spousal maintenance simply based on the calculations, that's when you would want to ask the court to look at a deviation, but you're going to have to demonstrate and prove to the court why it should consider making a deviation. This is used right now in Maricopa County, but could be used in any county. It's a fillable worksheet. Again, fairly similar. It begins with background information, family size, you see there. That's where it all starts. So now, again, you see spousal maintenance income, any attributed income, and I put in 2,000 because that could be net rental income. That could be investment income from an investment account. Spouse 2, that's what used to be roughly minimum wage. So Then you see below on family mortgage principal, put in 1,000. I'm not sure where 988 came from. And you're going to see the numbers update again. Now you're going to see these ranges. You can use this worksheet to come up with the same monthly range. And again, this shows, and I think this is because of the amounts. If you look at line 54, you see their payee share. So this is where it's subtracted an amount for the spouse who's already making, earning monies. And I think it may not be printing out the numbers or showing the numbers correctly because we didn't provide all the information up above. But this is just an example to show how you would, once you complete the family size and the amount of spousal maintenance income, or with any attributed income, it then will show you this range for the bottom line. If you're looking at line 55, that's where you will usually see an amount range. And I can't tell you, I apologize, exactly why it isn't showing, but that's where you would look at the monthly range. And this is the most current version of the spousal maintenance calculator. Same process as what we were looking at with the PDF picture screenshot from the Arizona Supreme Court. It's just in a little different format. This is an Excel spreadsheet. When you go to print it off, it will look very similar in terms of the amount requested. There you will see again how it would print out. It shows all the information, has all the data, the personal information up at the top. And this then would show the court the range that you're looking at. And you would obviously then have the amount that you're requesting. And it justifies then the amount that you're requesting from the court, or shows the court what it would be if there was not a deviation. The issue of temporary orders also often comes up. So temporary orders are the orders that the court can put in place upon a request from the beginning of the case until the end of the case. Obviously, temporary orders. The policy and the goal of the court is to try to keep the status quo in place that's already been occurring. So if there's a spouse who's already earning monies and he's been supporting the family, the difference is that, and the court would want to look at the spousal maintenance guidelines to see what the amount might be. The court will not, however, attribute income as part of temporary orders unless that spouse, the spouse requesting spousal maintenance, was already employed full-time for the past 2 years before the beginning of the case. So if this is maybe the typical stay-at-home mother or father, and they have not been employed in the past 2 years, as part of temporary orders, the court will not include income for them that they're not actually earning. I hope that makes sense, but that's something that courts sometimes have done. And now the Supreme Court says, as part of temporary orders, that will not be done unless the spouse has already been working for the past 2 years. Court does need to look at the expenses that are being paid by each spouse as part of temporary orders. So if a spouse is ordered to pay $7,000 of the $10,000 in community living expenses, the calculator will probably generate an amount of $4,000 a month. That should be adjusted to take into account that spouse is already paying certain expenses directly. Maybe it's the house that they're continuing to share, maybe it's a vehicle, but the court is directed under the spousal maintenance guidelines to adjust the spousal maintenance amount for the community expenses that are still being paid by the payor, the person from whom the spousal maintenance is being requested. The temporary spousal maintenance orders can be looked at the court at the end of the case and modified, but otherwise the court would conduct a brand new calculation as part of trial and the final orders of the case. So the temporary orders are simply that, temporary orders.
Thank you for joining us.